I have watched constitutional protections collapse through procedural exceptions before, not through dramatic confrontations that make headlines, through technical language buried in subsections of state codes that expand quietly until millions of people are subject to searches without warrants, and most never realize the protection was removed. The Supreme Court just issued a 9-0 decision that strikes down a state law allowing warrantless administrative searches. Every justice agreed. The conservative majority and the 3 liberal justices all signed the same opinion. This was not a narrow ideological split. This was the entire court speaking with one voice to tell state governments that administrative convenience does not override the Fourth Amendment. The case is Thompson versus State of Oregon, and it involves a law that was on the books for 7 years before anyone challenged it successfully. 7 years during which state inspectors conducted thousands of searches of homes and businesses without warrants, without probable cause, and without any meaningful oversight. The law was written in technical regulatory language and buried in the state administrative code. It never received public debate. It was inserted into a broader regulatory reform package and signed quietly. The law authorized state agencies to conduct inspections of residential and commercial properties to verify compliance with health, safety, and environmental regulations. But the law included a provision that allowed these inspections to occur without advance notice and without a warrant, if the inspector determined that obtaining a warrant would be impractical or would compromise the effectiveness of the inspection. That exception became the rule. Over 7 years, state agencies conducted more than 84,000 inspections under this law. In fewer than 200 of those cases did inspectors obtain warrants. The standard operating procedure was to show up unannounced, invoke the administrative inspection authority, and conduct the search. Property owners who refused were threatened with fines, license revocations, and criminal charges for obstruction. The Fourth Amendment protects against unreasonable searches and requires warrants based on probable cause. The Supreme Court has recognized narrow exceptions for administrative inspections in certain highly regulated industries, but those exceptions require either consent or a warrant based on a showing that the inspection is part of a neutral enforcement scheme. The Oregon law eliminated both requirements. Inspectors did not need consent because refusal could be penalized. They did not need warrants because the law gave them blanket authority to determine when warrants were impractical. This created exactly the kind of unchecked government power the Fourth Amendment was designed to prevent. State officials could decide unilaterally to inspect your home or business, show up without notice, and conduct a search. If they found violations, you could be fined or prosecuted. If you refused entry, you faced separate penalties. There was no prior judicial review. No neutral magistrate evaluated whether the search was justified. The law remained largely invisible for years because most people who were searched did not realize they had the right to refuse or challenge the search. Business owners assumed inspectors had authority. Homeowners assumed that if a government official showed up with credentials, they had to comply. Sarah Chen was a civil liberties attorney in Portland who started noticing a pattern. Clients would come to her after being fined or having their licenses suspended based on evidence found during warrantless inspections. When she asked whether inspectors had warrants, they said no warrants were presented. Chen began filing public records requests and discovered the administrative code provision that authorized these searches. She documented cases where inspectors entered homes to check for code violations and ended up searching entire properties. She found cases where business owners were subjected to searches that lasted hours, with inspectors combing through financial records and computer systems looking for any possible violations. The inspections had become general searches, the exact practice the Fourth Amendment was written to prohibit. The case that reached the Supreme Court involved Marcus Thompson, a veteran who owned a small manufacturing business in rural Oregon. State environmental inspectors showed up at his facility without advance notice and demanded entry to conduct a compliance inspection. Thompson asked to see a warrant. The inspectors said they did not need one under state law. Thompson refused entry and was charged with obstruction. The state also initiated proceedings to revoke his business license. Thompson fought the charges. His attorney argued that the warrantless search violated the Fourth Amendment. The trial court ruled that the state law authorized the search. The case was appealed to the Oregon Supreme Court, which upheld the conviction in a 4-3 decision. The dissenting justices warned that the law granted unchecked power to state officials, but the majority deferred to the state's interest in efficient regulatory enforcement. Thompson's attorneys petitioned the U.S. Supreme Court, and the court agreed to hear the case. The state defended the law by arguing that administrative inspections are necessary for effective regulation, that requiring warrants would be burdensome and would allow violators to hide evidence, and that property owners retain protections, because inspections must be conducted for legitimate regulatory purposes. The Supreme Court rejected every part of that argument. Chief Justice Roberts wrote the majority opinion, and it is a decisive rebuke of the state's position. The opinion runs 42 pages and methodically dismantles the legal foundation the state tried to build. Roberts begins with the text of the Fourth Amendment. It protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Those protections apply to administrative searches, just as they apply to criminal investigations. The fact that a search is conducted for regulatory purposes, rather than criminal prosecution, does not eliminate the Fourth Amendment's requirements. The state argued that the exception for administrative inspections in highly regulated industries should apply. Roberts acknowledged that such an exception exists, but explained that it is narrow and requires specific conditions. The industry must be pervasively regulated, such that businesses have reduced expectations of privacy. The inspection program must be established by statute and limited in scope, and there must be a constitutionally adequate substitute for a warrant. The Oregon law met none of those conditions. It applied to all residential and commercial properties, not just highly regulated industries. It gave inspectors unlimited discretion to decide when and where to conduct inspections, and it provided no substitute for the neutral oversight that a warrant provides. The law essentially told inspectors they could search whenever they believed a warrant would be inconvenient. Roberts wrote that if compliance with the Constitution seems burdensome, that is precisely the point. The Fourth Amendment was designed to make government searches difficult. It forces officials to justify searches before a neutral magistrate. Those requirements are inconvenient by design because they protect against arbitrary searches. The opinion emphasizes that administrative searches are still searches. Calling something administrative does not remove it from the Fourth Amendment's protections. The government cannot create an exception to constitutional rights simply by labeling its actions differently. If state officials want to search homes and businesses, they need warrants. Justice Thomas wrote a concurring opinion arguing that even the existing exceptions for administrative searches are constitutionally questionable and should be reconsidered. He traces the history of the Fourth Amendment and shows that the founders did not recognize categories of searches that could be conducted without warrants. Justice Kagan wrote separately to emphasize the practical consequences of the Oregon law. She describes specific cases where property owners were subjected to invasive searches based on nothing more than an inspector's decision. She notes that the searches often expanded beyond their stated purposes. She concludes that these general searches are exactly what the Fourth Amendment prohibits. The decision has immediate nationwide implications. At least 11 other states have similar laws authorizing broad administrative inspections without warrants. Those laws are now constitutionally invalid. State agencies in those jurisdictions must either obtain consent or get warrants before conducting inspections. Property owners who were previously searched under these laws can challenge any penalties or license revocations that resulted from evidence obtained through warrantless searches. The decision also establishes clear standards for when administrative inspections require warrants. If the inspection is not part of a pervasively regulated industry with reduced privacy expectations, a warrant is required. If the inspection program gives officials discretion about when and where to search, rather than following a neutral predetermined plan, a warrant is required. If the stated justification for avoiding a warrant is merely that obtaining one would be inconvenient, a warrant is definitely required. For homeowners, this means state and local inspectors cannot enter your property without your consent or a warrant, even if they claim to be conducting routine compliance checks. You have the right to refuse entry and require them to return with a warrant. If they threaten you with penalties for refusing, those threats are unconstitutional. For business owners, the same protections apply unless your business operates in a pervasively regulated industry where reduced privacy expectations have been established. Even in those industries, inspection programs must follow neutral plans that limit official discretion. For people who were searched under laws like Oregon's, this decision provides grounds to challenge any adverse actions taken based on evidence from those searches. If you were fined, had your license suspended, or faced criminal charges based on a warrantless administrative search, you can argue that the evidence should be suppressed. This 9-0 decision demonstrates something important about constitutional rights. They do not enforce themselves. Marcus Thompson could have accepted the obstruction charge and the license revocation. Instead, he fought back, took his case through the courts, and ultimately convinced 9 Supreme Court justices that the state was violating the Fourth Amendment. His willingness to challenge government overreach just invalidated similar laws in a dozen states and restored constitutional protections for millions of people. The decision also shows that constitutional principles can transcend partisan divisions. This was not a 5-4 decision along ideological lines. Conservative justices, who typically defer to state authority, and liberal justices, who typically support regulatory enforcement, all agreed that this law crossed a constitutional line. That unanimity sends a powerful message. For those who value limited government, this decision reaffirms that the Constitution constrains state power even when that power is exercised for ostensibly beneficial purposes. For those who value civil rights, this decision reaffirms that privacy rights apply equally to administrative actions and criminal investigations. The case establishes that a law can operate for years, affect thousands of people, and still be struck down unanimously once it receives proper constitutional scrutiny. That should concern everyone, because it suggests how many other unconstitutional laws may be operating right now in regulatory codes that never receive public attention or judicial review. This is not the end of the battle over administrative searches. State agencies will continue pushing the boundaries of their authority. New laws will be written with more careful language designed to fit within the exceptions the court has recognized. But this decision creates a clearer line and gives property owners stronger tools to resist. It documents that a hidden state law authorizing tens of thousands of warrantless searches just fell unanimously, and it proves that constitutional rights, when finally asserted and defended, still have the power to check government overreach, even when that overreach has become normalized through years of unchallenged practice.